Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
Well, we got Sagi Shaked here today. And Sagi, out of all the people who have ever been on my podcast, I'm pretty sure that I've known Sagi for the longest amount of time. Do you remember when we first met, Sagi?
It was back in one of the AAJs. You showed up. I just can't remember which one it was, Chicago or Baltimore. It's been a long time, over a decade for sure, right?
For sure. I'm going to go with Baltimore because I remember going with Connell to some bar and we had to take an
That's where I
Uber
met you.
there. And we walk in and there you were sitting at the bar. So I'm pretty sure it was, I don't know, I just really pretty sure it was Baltimore. Actually, I met Connell I think I met him at Cala maybe like a long time ago because anyways, not important. Important is that we did meet and where it was through, but with our buddy Connell, and we're gonna talk about it a little bit because you and Connell, who, both were young lawyers when I met you, or relatively, we were on your way up, and both have, because right after that, Connell went and got his $25 million verdict on that paraplegia case up in Bakersfield, which I got to carry his bags for. Never
That's
got on the
right.
record, but I got to do witness prep, got to be in the game, so I was very grateful for it. Even
Yeah,
got
he hit
paid a
it
little
out of
bit of
the
money
park.
at the end, so it was
Yeah.
exciting. I was like, wow, this civil stuff, this is going to be something for me. This is going to be perfect for me. But then at that time too, you really started, you weren't always, I mean, you didn't always have your level of success. You earned it, you worked for it, and you really, out of all the people I've known, you really learned your way to it. You know what I'm saying? It's like some people, you could say, oh, they're just born, and people like Panish, like his dad was a trial lawyer, or like Cal Paris, his dad was a trial lawyer. So, I mean, they were indoctrinated to become trial lawyers from a young age. Your dad wasn't a lawyer, was he?
No, my dad was a mechanic. Mom's a seamstress. My dad's a mechanic. So no, I didn't have any lawyers in the family. It was more of go in there and try any case that someone sent me, I would try, whether it was a disc case or sometimes sprains and strains. Forget about, I didn't even have herniated disc cases. I'd have sprains and strains. And you go in there, the defense is like, he doesn't even have a bulging disc. He's got a sprain and a strain. But, you got to take what you get. And that's what I got at the beginning. And so that's the types of cases that I would try. And then, over time, it gets better and better. I went from sprains and strains to bulges. And then suddenly I was able to move up to, I feel like I'm saying that script from, what is it called? The movie with Eddie Murphy, Coming to America, where he starts off with, first he was washing dishes, then he moved up to washing cabbage. But the same thing happened here. I started with sprain strains, went to bulging discs, then herniated discs, started getting some good results. And then they went to surgical cases. And at some point, I think it was probably like 10 years in, I realized the orthopedic cases are good, but the TBI cases are 10 times better and much better. And I think you can do a lot of good for people as well. So started getting a lot of TBI work and, really proving up those cases, the invisible type of injury. So that was where it started changing for me. And then started getting some nice 7-figure verdicts and then got an 8-figure verdict and then got some other large settlements. And that kind of changed the trajectory for me, I guess.
Yeah, it's nice how those verdicts, I mean, actually, we were talking last night, you were telling me how much like that 8-figure verdict really, you know what I mean? It really changed how people saw you. Maybe not how you see yourself, but how the trial lawyer world saw you in the cases that people thought you were appropriate for people, because most people don't try cases. I mean, most people that practice law, even personal injury, last thing they ever want to do is see a courtroom. I mean, they're good
Right.
at getting the case, good at okay at working it up, but if they can't settle it, it's like panic mode for many lawyers and many law firms, and they call people like you or Raleigh or Panish to come in and help them, depending on what part of the country you're in. And so, but how did you first get the big idea, little tiny Sagi? Little when did Sagi get the idea? One day I'm gonna go to court. I'm gonna go to office and wear a tie every day, even though my dad goes to his office is a garage and he comes back with grease all over him and
He
dirty every
does.
day and grinding and we're learning a very lower middle class life. Where'd you grow up?
So I was born in Israel, lived in Israel till I was around 6 years old. Then we moved to the States, New York for a little bit, but mostly South Florida and Miami. And then my parents would always tell me that when I was little, I would be walking around with a little briefcase and just arguing all the time. And so that was ingrained in my mind. I'm going to be a lawyer. I'm going to be a lawyer. And it was my dad's dream for me to be a lawyer. And, I wanted to fulfill that. And also, I thought I would be good at it. I mean, initially, I wanted to play in the NBA, but I didn't have the skills, the speed, or, the luck. So you need a lot of it to be one of 400 players in the world. But that dream didn't come true. But, I did become a lawyer, and that's what I like doing.
A little bit different dream than the one of a NBA rock star. You get to be hey, being a trial rock star, it's kind of fun. You know what I mean? It may not, and you know what? May not be an NBA salary of like a Michael Jordan, but maybe like one of those guys that rides the bench. Maybe one, anyways. But it's all about learning, and you're one of the most prolific learners I've ever come across because way before Sagi was getting results, the whole time I've known you, which is probably more than 12 years now, you are always at we go to AAJ, which some people would argue is a lot of the presentations there are, extremely boring. And, most people that, I would say that, I don't know, at least the majority of people I know that go, we just hang out and go and socialize. And we're always waiting for Sagi because Sagi's always in class. So, tell us about that. You're always learning and what's behind all that?
I just constantly think I can always get better, and I'm always trying to get better. So if there's someone speaking that, whether it's from a different part of the country or even from Florida, I'm trying to learn, 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 learn. Because if we're learning and then applying, we're getting better. So my goal is to always try to get better. And there's always something I can take from somebody, whether it's a new lawyer or a more seasoned lawyer. I'm always willing to learn. And, I'll be generally sitting in the class, generally up front, because again, I want to learn, I want to soak everything in and then go back home and apply it. So when I go to these conferences, I get re-motivated, re-energized. I come back, I'm like, I'm psyched. I'm ready to try a case. I'm ready to take my depots again, get excited for these cases. That's me. I just like learning. So that's what I would say. It's fun to learn and it's fun to apply it. And then seeing how, looking back now, I can tell you what a difference it made, right? Going back now over the 25 years and going to all those classes, what a difference it made between other lawyers and what I do and continuously learn and what some other lawyers they don't want to learn. I don't know why, but some lawyers just get their degree and they just never want to do any work after that. I think that's a way to not succeed, and it's not fair really for your clients either.
No, because there's so
That's
much to
why what you
learn.
do is amazing. What you put together is Trial Lawyers University. It's one anyone who hasn't gone. Obviously, if you're a defense lawyer, don't come because you're not invited. But if you're a plaintiff's
Like,
lawyer,
fuck
we're not
off,
looking to
buddy.
educate the
You're
defense.
the wrong
Uh,
team.
yeah, yeah, we're here on the plaintiff side. We're sharing information, sharing knowledge, trying to help people, victims who have gone through a lot in their life, whether it's a small case or a big case. But when people share, that's how we get better. And the fact that you put this, I remember when we first started off, it wasn't what was it called before? It was Trojan Horse, I think.
We started out
Yeah.
as Trojan Horse,
Yeah.
and then before the pandemic, I came up with this idea to do a case analysis of doing like breakdowns of people that got verdicts, and we do them live. And it was pretty cool because the first one we ever did was with Chris Dolan, like 100 people. It was like 100 people there, and I was like, wow, this is a whole new way to meet people and, and make a few bucks. I think I charged like 300, I charged like 200 bucks, 300 bucks a person or something. Plus, obviously there's expenses, there's coffee, well, back then we didn't have food. I was like, this stuff's too expensive. But, but it was a really, I got to meet so many people and really learn trial strategy, right? How do they go about putting these cases together? Because you can have all the performance skills in the world, but if you don't know how to put it together and, strategically and utilize depositions, interrogatories, and take great depositions, it's like, forget about,
Yeah, and
who
then the
cares
wealth
about your
of
performance
knowledge.
skills if you don't got the evidence? So
No, but the wealth of knowledge that you accumulated from doing the case analysis in COVID, at least between, speaking to Lanier and all these other great trial lawyers, John Romano and everyone else, you're speaking, you're getting all that knowledge from them from case analysis, and then you put TLU together. It's just an amazing for someone who wants to learn and really get good. It's a must, that you attend and that you actually learn from this stuff.
well, if you attend, it's like, it's not like most conferences that we talked about where people just go and hang out, especially like the beach conference that we have coming up. Because you were there last year, but that was your first year at the beach?
That was the
for a
first year
second.
at Huntington Beach, yeah.
Oh, like, to me, that's my favorite conference out of all of them. I mean, Vegas is twice as big and, it's Vegas, but Huntington Beach, just because we bought the whole hotel, so it's like, feels super intimate. There's great restaurants right there. You never have to get in a car if you don't want to. You can just go right next door to one of many great restaurants, and, the food at the hotel is great for breakfast and lunch, and, and then the great people, the great, trial lawyers that come and teach in, like, these smaller classes, like, in addition to like this TBI masterclass, you've been studying this shit for 20 plus years and, really learned how to work these things up and figuring out what everybody else did and taking the best practices. And now you get a chance to like, you and Connell to do this class and teach people how you do it, from intake to, to go into trial. I mean, there's just so many things to do and so many mistakes that can be made. And one mistake could be, fatal. I mean, people that don't properly medically manage their clients. It's like,
Even this morning on one of the listserv, I saw an email. I was not going to say which one because, obviously it's confidential, but one of the emails came in. The guy's like, I got a neck case and a concussion. I'm like, in my mind, all right, the guy got a concussion at the scene. That's a brain injury, but didn't treat it as a brain injury. He's looking for chiropractic to refer a case to a chiropractor. And that's not the way it should be done. I mean, a person got a concussion, they're going to have lifelong symptoms from that. And that's what we really need to address. What kind of cases are TBI? Like, what do you really need to look for to determine that you have one of these cases? This is one of the things that I'm going to talk about at that masterclass.
well, let's talk about that. I mean, because like I've been doing this a while, but I don't have a lot of experience in TBI. I mean, I do in breaking down verdicts, but taking, somebody came to me and said, "Hey, I got hit in the head by, this UPS driver." I'm not gonna, and it's the case I want to handle myself because whatever reason, I want to keep all the money or I don't like working with other people, I'm antisocial, whatever the case may be. So let's just talk about, you know, like the intake process. Like how you know if you have a TBI case and what kind of stuff are you doing from the intake to identify it?
Yeah, those are great questions. And so when you think about a TBI, everybody really thinks about the person who's had brain surgery as a result of an impact, whether it's a collision or a fall on the head or someone struck them or a blast. But those are the obvious cases, right? The ones just stare you in the face. You don't have to be some rocket scientist to identify this person, had a craniotomy where they opened up the person's brain and they're going to have residuals. That's easy. But even if you have that case, you still need to work it up if you want to maximize the case and get full measure of justice for the client. But now let's roll back and think about what we're doing at the TBI masterclass. I'm going to be teaching, one is how do I identify the case? So when a case comes in, all the red lights are going off in your office and saying, well, wait a minute, this isn't your typical run of the mill type of case. It's not a my neck hurts, it's a whippy type of case. You're talking about someone's brain that's been impacted. Their CPU, right? Their CPU that controls everything in their body. So when you throw a computer, or let's say a computer gets dropped on the floor, it's just never going to operate the same. That's the same thing with the human brain. So what we're doing in the master class is one is how do you identify when you have a TBI? Don't be like I was when I was a younger lawyer because it took me a long time going to a lot of years of classes to figure out, whoa, I missed the boat on a couple of cases in the past. So what I'm going to do during the class is help every single person, whether you're a younger lawyer or a more seasoned lawyer, take a different approach when you have your cases. Look for the TBI, look for the injury to the brain again. And sometimes it's not so obvious when you have an injury to the brain. Everyone, again, thinks you have to be struck in the head. You don't. We're going to talk about the mechanics of how a TBI can happen. You can have a TBI from a rear ender where your client's head never smashed into the windshield. And so we're going to talk about that, the signs and symptoms, what you need to look for to determine if a person has a traumatic brain injury. And again, when we have these cases, if you're just going to trial, which I see some people doing, and they're not getting good results, just going around waving up, I have an MRI, here it is. It says he's got lesions in the head, and relying strictly on your MRI, you're going to probably lose. It's just not enough. You need to try not just the case, not just a traumatic brain injury, but try what are the symptoms from it? What are the long lasting nature of the injury? Meaning not just keep saying TBI, TBI, what do they have? So if they have eye issues or they have ocular issues or hearing issues or balance issues, dizziness, that's the kind of stuff the jury needs to hear about, not just you throwing it down their neck, traumatic brain injury, traumatic brain injury. We need to really bring it to life. So that's kind of what we're going to do. We're going to identify at the beginning, how do you find these cases? And I guarantee you that everybody has them. Everybody has. If you look at your files, you have somewhere where someone was dizzy at the scene, whether they lost consciousness or not. They don't have to lose consciousness. And I'll show you the literature on that just in case an adjuster comes to you and tells you, oh, they didn't lose consciousness. That's like the typical defense. You see that with every CME or DME, whatever you call it in your state. The defense doctors will say they didn't lose consciousness, so they can't be brain injured. Or the adjuster will tell you the same thing. It's the brainwashing the defense tries to do on the lawyers who don't know the medicine. So we're going to teach you the medicine a little bit, teach you how to detect it in the early stages. And that'll be probably the first hour on how to detect it. I know it sounds simple. It is simple if you learn what to do. And I'm going to teach you what to do. I'm going to give you impart some of my 25 years of knowledge and help you identify it so you can maximize the cases for your clients and get them full measure of justice. Because again, you have people who 10 years later start seeing the residuals. And I think the easiest one to talk about is when you have CTE. We've all heard of CTE, the football players, their helmets, they hit each other like, going in like Mack trucks. You see it later on in life. They're committing suicide. They're doing all types of crazy things, all because their brain was injured. They seemed normal after the game, but now it seems like the NFL is taking a different approach to that. I know the Miami Dolphins are suffering because Tua continuously gets taken out of the game because of his multiple concussions, and there go our season every single year. Hopefully, this year will be different, and the Dolphins will play a full season with Tua, and we'll make it to the Super Bowl.
I know that I'm sure when I speak for the whole country when we say we're rooting for Tua and the Miami Dolphins in the Super Bowl this year, for sure, for sure. And then, you
The
talked
odds
about
are
that
good, by the way, in Vegas. If you bet the Dolphins to win the Super Bowl, you're going like on a 60 fold. So
as far as like identifying it, like what are some of the key things that people make mistakes on and that you think are best practices, even in that first initial intake when you're doing the assessment, asking the right questions, starting to identify perhaps before and after witnesses. Tell us about, what's that?
So you get that phone call. You really want to find out at the scene. The easiest one to help the insurance company is the loss of consciousness, meaning they passed out, blacked out, passed out, whatever you want to call it, loss of consciousness. But sometimes you don't need to pass out to have what's described according to the American Medical Association as loss of consciousness. You can be dazed and confused, or just dazed or confused at the scene. Sometimes you're asked a question, or the client is asked a question, and they don't know what day it is, or they're confused as to what happened. They're confused if they had their seatbelt on or not. They don't remember things. Sometimes they don't remember the crash occurring. They'll get to the hospital and they just don't remember. And that's a sign of a loss. That is loss of consciousness. But sometimes they don't understand that that's a loss of consciousness. So you really have to screen, and that's one of the big things. If they're dizzy, they're dazed, confused, and that's your first indication that a little light bulb should go up in your head and say, whoa, we're dealing with something different. This isn't your typical neck and back case. We got to address this case differently.
And the process of addressing it differently. This guy comes in, you determine that may have a TBI based upon your interview and all the information you gather. And so from there, what's the next step as, handling this case, specifically as to, the medical treatment that you go
So
through?
yeah, so it depends. Did your client go to the hospital? Did they not go to the hospital? Have they been to their primary care physician or not? What I like to do in the office, and I'll show this at one point in the master class, we're going to talk about what we do when a client comes in. We go through, there's about 26 things that we go through when we sit down with a client, whether it's by Zoom or a telephone call. Of course, this is attorney client information, it's protected. So if you come to the class, you'll get it. It's never going to be produced to the defense. So if you're listening, don't worry, you're never going to get it. But basically, we go through items. I'm very pro plaintiff, as you can tell. We go through every single item. I want to know if they've had it in the past. I want to know if they have it afterwards. Are they experiencing, for example, we talked about the confusion, or we talk about nausea, dizziness. There's some other items there that we'll go through in the class, but this just gives them an idea. It gives you an idea of and shows the client, look at how different you are from just what happened to you. Now we need to make sure that you're constantly looking at this on a daily basis moving forward. And you really need to be in touch with your clients a lot. You need to have, I mean, if you're dealing with volume, it's harder to do TBI cases because you really need someone to be with the client, talk to the client a lot. So this requires a lot of work. This isn't for, I mean, I guess if they have enough people, they can do it, but you got to constantly care about the client and you call the client and you want to know what's going on with them. And so you talk to them even after they go to their doctor's appointments. You want to know what's going on. You got to stay informed. What are their complaints? Because sometimes people don't recognize that the complaints they have are caused from the injury to the brain. I mean, we've had people with eye vision issues. They didn't realize that was from an injury to the brain. They wouldn't have known. So it's your job as the attorney. You have to act as a forensic. But to be a forensic, analyst in these types of cases, you really have to understand the medicine. And when you understand the medicine, then you can be in a position to help people and to get your client that full measure of justice.
When you say understand the medicine, what do you more specifically refer to? Because, it's such a general statement. Like, what's the
Right.
medical TBI that you need to understand if you're going to try to do this let alone a very high level?
Understand how to identify the signs and symptoms, understand how to read those records so you can further identify. And then if your doctor is not, doesn't know the medicine specifically, they might be a generalist. You need to get it to a specialist. Generally, when you have a traumatic brain injury, you're going to want your client going to a neurologist, someone who understands the brain. So when I say understand the medicine, it's specifically medicine related to how to diagnose a traumatic brain injury. They didn't tell me that when I went to law school that I'm going to have to learn all this medicine, but it's part of the job when you do personal injury, right? We're dealing with injuries. So you really have to learn the injury, understand it. What are the long term natures of it, the duration of the injury, the intensity of the injury, the frequency of their injury, how long lasting it is, how do I identify it? Which ones last longer? Which ones don't? Which ones impact the person's life? Which ones don't? So those are the kinds of things we're going to talk about at the masterclass.
How about imaging studies? Because you hear about all these different types of imaging studies, and some are accepted, some aren't, some are reliable, some are specific, some, they don't show anything, yet the person's still hurt. So how do you
That's a
know?
good point. So we're definitely going to talk about imaging. We're going to start off with CAT scans or CT scans, as they call them, and we'll move up to MRIs, some PET scans as well. But generally, one statement you can take from today, without going to the master class, but we encourage you to come, is if you get a negative CT scan at the hospital, do not say this is not a brain injury. Most of the CT scans in your mild traumatic brain injury. So brain injuries right now, they're categorized. The way the medicine works right now is into three different categories. You have mild, moderate, and severe. So you have three categories. The severe would be the person who, passed out for a very long time, maybe even had an operation on their brain, bleeding in their brain. The mild is where I'm going to be teaching you how to recognize the mild traumatic brain injury or the moderate one, and then help your clients through that and make sure the doctors help your clients. So we're going to look at that. What is a mild traumatic brain injury? How is it defined? And then how do we go about, again, recognizing it, identifying it, and then making sure we're getting the client to doctors that can really help the client get better.
And in these cases, the insurance company, they have they have a lot of defenses. Some have merit, some don't. And so how do you go about recognizing and building a case that overcomes whatever defense roadblocks they'll be throwing up?
Yeah, it seems like the defenses get more creative as time goes by. So one of the defenses we talked about imaging, and then I'll go back to other defenses. in a second. But one of the defenses is they always say the CT scan was negative, so we can't, there's no way that they can have a brain injury. Again, that's not true. You're only going to see bleeding on a CT scan if it's major bleeding. If it's minor, you're probably not going to see it. And that's why you need a different type of diagnostic tool. So now let's go to the defenses we talked about. We're going to do about an hour to an hour and a half just on defenses. There are so many. So another defense, first we talked about the CT scan is normal. Another defense is if there was no loss of consciousness, it can't be from, there is no brain injury. You didn't suffer a brain injury. Everyone that you have to have loss of consciousness. Now it'll depend on your case because if your client had loss of consciousness, that expert goes away from that defense because they're not going to say that. They're going to say that the person healed. It's 6 to 12 weeks and they healed. So if you don't have a loss of consciousness, I have the literature, I'll share it with everybody. You still can have a brain injury. You don't need to have loss of consciousness. So there's different defenses that we're going to talk about and how to address them. Some are ridiculous, but juries sometimes they resonate with juries. So we want to know which ones resonate, which ones don't, and which ones and how to attack them. And there's different ways to do that.
I know malingering is like a common defense in these cases.
Correct. Everyone's faking it. All your clients are faking it. They can't be real. Look, if you're trying a case with a scratch on a car, that's a tough case. I'm not saying you can't win it. I've tried those cases and we've won some, but they're tough cases compared to there's an impact on the car. There's something that you can see because remember, you're going to have in Florida, it's 6 jurors. I guess in California, it's 12 jurors, but you're going to have, I think it's 12. Is it 12 in California, Dan?
Yes.
Okay. So you're going to have 6 people coming in from, or 12 people in California or some other states, all different walks of life, and they have different life experiences. So when a person has a different life experience and they're going to be like, shit, I'm missing 3, 4, 5 days of work for this. It's BS. I'll give you an example. I didn't get picked for jury, but I got called for jury duty, and it was in the civil courthouse. And while I'm in the civil courthouse, it's funny because I knew the plaintiff's lawyer, I knew the defense lawyer, I knew the judge, I knew the bailiff. I had tried cases in that courtroom. So I'm sitting there and they're asking questions, and you can see the difference between lawyers on how that affects jury selection. One lawyer did amazing. It was the defense lawyer. He did a really, really good job and it got the jury involved. They were all laughing. By the time we broke, because they were going to now select the jury, right? At the not in the, and the jury's not present. We all started walking out. The people, before they even heard anything, we're walking in the elevator. They're like, "This is bullshit. I don't want to miss time for work for this shit. That guy's guilty." Remember, this is a civil case. They're already saying that guy's guilty. He doesn't deserve a penny. Why are we here? Why are we wasting our time? This is a bullshit case. So you really got to be careful about who you're picking. Obviously, I didn't get chosen on that case. The defense lawyer, we had a trial the
What a
following month. We
surprise.
ended up settling, but he didn't want to choose me because that would have been the largest verdict for a scope knee case in the country. But no, I would have been fair and objective. I really would
Of course you
have.
would have.
The highlight of TLU for me was having the opportunity to network with attorneys from out of state.
TLU has been amazing. I'm so glad I came. It was one of the most inspiring events I've been to. Great networking, great food. It's been amazing. I can't wait for next year.
Okay, so we now, let's say you work the case up, and if we could resolve it for full value, I know you had resolutions with 9 figures in them, right? I mean, in excess of $100 million. I mean, and it's hard to turn, to get to 100, you got to turn down 80. Just like to get to 150, you got to turn down 120, and that takes it takes a different level of cojones to do that kind of stuff, but still you're getting every case ready for trial, but also, as my friend Sagi Shaked says, you got the trial battleship and you got the settlement battleship. So when you're building these cases, I'm sure your mind is in both places. You're building it for settlement, but also getting ready for trial. So, when you put it together, give us how you go about like building the economic and the non-economic aspects of your case.
So, I mean, if we're filing the lawsuit, I'm going to get ready to try that case. So I'm building it as if I'm trying the case. I'm not going to put a case in suit that I'm going to try to settle because sometimes I know from my past, they just don't offer you money and you're in there trying a case you really shouldn't be trying. So I'm not telling you not to try cases, definitely try cases, but you really have to screen the case, make sure the medicine makes sense, make sure that you can tie it all in. I'll give you an example. I think we were talking about this before we went on. I had a case when I was young. I was, winning a lot and have a good string of wins and thought I was invincible. Like
It's
Everybody does.
amazing how that happens with trial lawyers, huh? You
You
win a
get
few, you're
humbled
like, "Man,
quick.
I'm the man. I'm like Superman. Like, juries love me. It doesn't matter what I say. I can win the craziest cases."
Yeah.
Trust me, we all have those. I think every trial lawyer has some winning experience, starts to get those megalomania thoughts like, "I'm invincible," and until you get punched in the face.
Right. You get
Like
humbled
Mike Tyson says,
quickly.
"Everybody's got a plan till they get punched in the face."
Yeah, so I got humbled in that case. It was a guy. He had, I think it was like 2.5 to 3 months before he went to a doctor after the crash. And I'm like, I'm good enough to convince a jury. In my mind, at least I thought that. And you go down there and you try the case, and then you realize you had a real hurdle, or I had a real hurdle to get around that gap before they started treating. And so what happens is when you try a lot of cases, this is for me at least, and I think it's true for everyone, you start learning what juries like and what juries don't like, and what works and what doesn't work, because you're doing what you like to say is the repetitions. You get in there and repeat, and try to get better and better and better. But you also learn from the mistakes you made, and a lot of the mistakes I used to make was intake. Right? Am I taking the right case? And sometimes you think a case is interesting and you're taking it, and I'm like, oh, that's not a good
Or
idea.
you like the client, you really connect with that client, you're like, "I could tell
Yeah.
this story."
I feel bad for them. I want to help them. So, I got better at intake. And as a result, our results are up, right? We're getting bigger results, better cases. I'm just more selective at the cases that I take. Now, I can do that now after 25 years. But when you start off, the younger lawyers, I don't think you can do that. You have to take whatever comes in the door and then try the sprains and strains and let the insurance company know you can try every type of case. So when you do get that monster of a case that you can really make a difference in someone's life, you've had so many experiences. Who cares if you lost a couple of them or a bunch of them? Who cares? You got better and you don't make those mistakes anymore. So repetition, the reps, key. So I truly believe in what you're doing at Trial Lawyers University. Not trying to make your head bigger than it is, Dan, but it is a good thing that you're doing.
And so you have to practice in the deposition. You practice in motion hearings. You practice at the grocery store. That's why you have a family. You practice on them. You have to keep the skill up or it erodes. It's simple as that.
Somebody give us an overview of this case.
Or I call wowing it. And what I mean by wisdom of the wise is, why are we still right in spite of this fact?
These are just some of the clips when I was cross-examined 10 years ago, remember that.
About 11 o'clock at night, and he leaves this message. I got a brilliant idea. Every conversation he starts, I have a brilliant idea.
But welcome, everybody. We've got a good crowd here today.
Sagi's a TLU On Demand subscriber.
I am.
Watching on a regular basis. He's like, I don't need to watch a student for your webinars. I can just watch whenever it's convenient for me.
Right.
Today, you want to watch the one that we do later today, though, because it's going to be on performance skills with the new case that we have with the video from inside the cab of the motorcycle truck crash. Yeah, it's picture of the scene that's a real, you know what I mean? Like, this is a case that I think resonates more with people than my previous one. But the tanning salon one's good too, because it teaches a lot of skills on space creation, movement. For example, if you have an employment case, the skills of the presentation taught in the previous, the tanning salon, I think would be more apropos than the trucking crash case. But still, once you understand, connection, the eye contact, controlling your facial expressions, controlling your hand movements, controlling the pace of your voice and the inflection of it, using visuals effectively. Once you understand all this stuff and really creating space, which is really the critical one that most lawyers have challenges with, like really imagining, because they're so like cerebral and, words, getting past that. But Sagi, let's say negotiations break down and we got to go to trial. In your class, I know part of it deals with the trial. I know Nick Rowley's doing a TBI masterclass that's basically, from my understanding, mostly just all trial and not the time that takes, not the 4 years that takes to get there. Just, that. And Nick, he both, I just did a case analysis with him a couple weeks ago. It was a case that he'd been litigating for 8 years, or his team been litigating for 8 years. So he has ones that he's babysat for all those years and ones that he comes in at, and he's in trial right now with my buddy Michael Carrillo on a sex abuse case. And he just, finished a Starbucks hot coffee case a couple of weeks ago. So that's where they live, is in the courtroom. And then other people have to build it up and work all the cases and, and then get to the courtroom, which is, I think most people. So when people get to the courtroom, how is your masterclass going to help people who, when they get to the courtroom?
Once you take the masterclass, you'll have a better idea of what happens in the courtroom, because you can't just take any case and think it's a TBI case. You really got to work it up. You got to have the evidence. So if you just have, for example, like we talked about earlier, just an MRI, it's a tough way to win a case for a TBI. You really got to pound on the evidence. I like to say, put on a mountain full of evidence to show them this isn't just one little test that we have. We have a bunch of tests. And then you bring in your before and after witnesses. We're going to show you some before and after witness videotape depositions that we've taken that can really move the needle in your case. But so that's the kind of stuff we're going to talk about. How to work it up over the course of, sometimes it takes years to get there, sometimes it's a year, but how to work up the case to make sure you have that mountain of evidence when you're going to trial. And so you can be able to prove your case, because you can be the greatest trial lawyer, but if you don't have evidence, it's not going to really help. You need the evidence. You need to work up the case the right way. And hopefully if you work it up the right way, they pay you a lot of money. And if not, then you're armed and you're ready to go to trial and you're able to prove your case. Otherwise, you're sitting there and you don't know what you're doing.
You're terrified. So I'm going to, like on the voir dire, because I hear a lot of different TBI voir dires. So I have one myself. I don't know if I shared it with you recently, but I'm going to share it with you now. It's my invisible injury voir dire. So it doesn't matter if it's a TBI, PTSD, depression, because these are all in pain. These are all invisible injuries, right? We know the client person's suffering because they're our clients. We spend a lot of time with them. We know their suffering's real. But for other people that can't see it, like a leg amputation, well, it's a lot easier to, I guess, for them to imagine what the experience is like, whereas like the TBI. So here's my TBI / invisible injury voir dire. Ready? So folks, speaking of TBIs, let me ask you, who, traumatic brain injuries, who here has ever experienced one or know somebody, like a family member or a close friend, who has? And, they could be it could be something that was traumatically induced or something that maybe happened over time, like dementia, Alzheimer's. So, and then obviously as you raise your hand, it'd be, Sagi, who's this person to you? So do you know anybody that's had a TBI, Sagi?
I do.
Who? Friend, family member?
I've had friends and family members who've had TBIs.
Okay,
Family member, a young family member, yeah.
What was her name?
Jacob.
Jacob. Okay, so then I said, well, now Jacob's brain injury, was this something, can I ask you, how did it affect him? And so then you go the different ways. He can't remember, it changed his personality, it caused depression, blah, 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 right? And the different ways. So now we talk about, was he able to get any treatment for it? Did he do anything to help with it? And either yes or no. And if yes, what'd he do? He did cognitive therapy. What else do people do for TBI treatment?
And do vestibular therapy, cognitive, all types of therapies.
Right. And so they say, they know, and then did it help? Yes or no, right? Obviously, you want to hope that it helps, want their loved one to get better. And then they share that. And then was this therapy help? Did it help them get back to their regular life to become fully functional again? Yes or no, right? And so then you do that with a few people, whoever has the experience. And then the next part is, as you see, folks, these brain injuries, they affect each one of us differently. Sagi's nephew, Jacob, he experienced X, Y, and Z. And, they talk about things that was, and also we learn each one of us recovers, and, the modern medicine helps each person differently. We talked about this stuff because this is where we get our common sense from, our life experiences, and nobody expects you to leave that at the door. But if you come sit on this jury, you have to promise us all, each side, the plaintiff, the defense, and the court, that in fact, you're going to take these life experiences. And, obviously nobody's going to say, don't consider your life experiences. That'd be crazy, right? Because that's where we get our common sense from. But to make sure that you judge this case and your verdict is basically a clinical verdict, only based upon, the stuff that's inside the box, which is the law and the testimony and the physical evidence. And everything else is outside the box. And you can't consider any of that other stuff, and you can life experience guide us, but you can't say, oh, you know what? My dad had a brain injury, so I'm going to be much more prone to help the, be on the side of the defendant or the plaintiff, or you know what, the opposite, whatever it is. To be able to set them aside and judge the case only upon the evidence. So, does this make sense, to everybody? And Sagi, do you think you'll be able to do this? Sure, of course you say. And how about if somebody said, well, Sagi, because your nephew had this experience, you clearly going to be too sensitive, and you won't be able to judge the case fairly, and it'd be unfair for one side or the other. What would you tell that person? Right? Blah, blah, blah. What did they? That's crazy, right? So a little prehabbing to, prevent the people from getting kicked off. So, but I think that kind of framework
I like
works
it.
with every invisible injury. Like talk about, bring it up, introduce it, TBI, chronic pain, PTSD. Who here has ever experienced it or knows somebody who has, who has a close family member or a friend that has? Everybody's going to raise their hand. A lot of people are. Ask each individual who the person is for them and then how it affect their life, if they got any treatment that, for that, whether it helped or not helped, and then move on, right? And then have the conclusion to why did we just talk about this? So I think it works out well. And, and having, because I think voir dire is pretty much a script, as you know. I mean, I teach scripts, and I think if you read any great trial lawyer from one trial to the next, they're saying basically the same things. Nobody's reinventing voir dire every time they stand up and pick a jury. It'd be crazy, right? You got your pieces at work, make a couple customized pieces for the case, and hopefully improve a little bit every time. So
Right, it's all about connecting and trying to get them talking and that kind of stuff.
connecting. It's all about connecting, getting them talking, but also leading the conversation and, being able to lead it so you get constructive information for preemptory causes or challenges for cause, right? I mean, that's the whole idea. Build a tribe, but also get people to expose themselves so you can get rid of those toxic jurors that are going to destroy your verdict no matter how hard you work. Everybody's looking forward to your masterclass with our buddy Connell. But
Yes,
speaking of teaching, you have a son, young son
I
named
do.
Tomer, who's planning to become a trial lawyer. So now that you have all this experience becoming a trial lawyer and the journey of a trial lawyer, how are you going to advise or guide your son, who's, what is he, a junior in college now or something like that?
Correct. Yeah, junior, sophomore slash. Yeah.
Yeah, like he takes a lot of credits every semester, so he's an accelerated one, obviously. But so, what kind of advice? How are you going to help him become a rock star at a much younger age?
By the way, my daughter is also going to law school, so I don't want to undercut her. I don't know if she wants to be a trial lawyer
That
yet
just
or
want to be a
not.
trial lawyer. We gotta pick out the people that want to be trial lawyers. They gotta have it like
Exactly.
in the DNA.
So yeah, he definitely will say what drinking the Kool-Aid. He wants to be a trial lawyer. He's indicated that he's been to a conference or two already. He wants to do it, and what I would tell him is you really have to train, sort of like Dan, you talked about me going to the classes and doing classes. I also took training classes. But what I would do for any young lawyer, I think the way to do it is you got to train, train, train. If you really want your results to to get to the next level, is the continuous reps, the continuous learning, always getting better, and then applying. Because you can have all the knowledge in the world. I think there's a saying out there, librarians, they read all the time, they have all the knowledge. But if you don't apply that knowledge, right, it doesn't mean anything. So you really have to learn, practice, repetitions, 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 get in there, make the mistakes, but you don't have to always make the mistakes in trial. You can make the mistakes like what you do, Dan, in your programs. I'll give you an example. So I'm in trial in West Palm Beach, and it's on CVN. And during the middle of the trial or at the beginning of the trial, as I'm doing my opening, as soon as my opening's done, I get a text message. Who's it from? It's from you, right? Dan Ambrose sends me a text and he's like, Sagi, we got to talk. I'm like, I know we have to talk, but I'm in the middle of a trial. He goes, well, I'm going to help you. So as we're doing this trial, the stuff you talked about earlier, you're helping me from the way you use your hands. And I know it sounds simple, right? But until you get in there and do it and you practice and get it better, it sounds simple, just like watching a basketball game. It looks pretty easy. These guys make it look easy. Steph Curry makes it look real easy to hit a three-pointer. Try doing that 10 times in a row or from the crazy places that he takes it from. It looks easy. It's not easy. It takes a lot of practice. So the more reps you get in there, you're going to get better. And look, I still, do reps. I still try to get better. I'm still learning. I've had some good success, but I still want to get better. I don't want to be judged by my last case. I want to continuously get better. And it's only fair to your clients. If you're going to take on clients and represent them, don't do it without continuously practicing, continuously getting better, and then educating yourself so you can apply that to help your clients. And in turn, you're going to help yourself. But that's the smaller picture. If you help your clients, you're going to make a lot of money, and you're going to get them full measure of justice. So that's kind of the goal.
Yeah, I think it's really a combination of, because people often ask me this question too. Hey, how can I? And I got a nephew, my nephew Harrison, who works for my buddy Mike Sanchez. But Harrison was just at my boot camp this past weekend with Bernie and, a bunch of other folks. But Sagi was supposed to be here, but apparently his work schedule. One day Sagi's going to make it. It's been a few times we've been scheduled, but it's going to happen.
I'm going to make it. I'm going to make it.
We're waiting for Tomer. It's going to be a father and son outing. The first, just like Panish passed the Nevada bar with his daughter. Well, you're going to come to boot camp with your son. So it'll be the first father-son combination boot camp. But I'm working on, obviously, I'm becoming a better trial lawyer, a champion trial lawyer. And that's why I'm not, I've got plenty of studying. Nobody's studied this stuff more in the last 5 years, walking the face of this earth than, yours truly, between doing my boot camps, training people. I've probably done that 70 times. This 4-day program. I've hosted, over 400 webinars, done all these live conferences. And so I have this great wealth of knowledge, but now I got to put it into practice. And that's where I'm pretty stoked this year. After June 7th, I got no Vegas, nothing else to, these boot camps obviously take up time to get ready for them and, do them, but not like 1,000-person conference takes up time and causes stress. It's like doing a big ass trial where you got everything on the line. Nothing else happens except that trial, right? It's like a 12-hour a day, 7-day a week obsession. But, so you got to learn, you got to study, you got to train. I mean, you got to train the physical aspects of being a performer. And that means because there's a best practices for everything we do. Like there's a best practices for witness preparation and direct examination. And, most people, they get a little book out or, they give people a script and it's, and then they wonder why their witnesses are terrible in deposition. And, then they blame the client for sinking the case, right? But they never did the work with the client to prepare them for this traumatic experience called deposition. Cross-examination. There's a best practices for it. And until you've been taught it, until you've been shown it, get a chance to actually try it, get feedback on what you did, like everything we do here at, TLU, we record. So that way people can see themselves because everybody thinks you're great. I hope you think you're great. You better think you're great if you're standing up in front of people. But the reality is when they look at themselves objectively is quite different. All the weird tics that people have, like biting their lip, grinding their hands, their body. It's just weird stuff that human beings have when we get up and try to perform under pressure. So the only way to deal with that is reps, but actually learning how to the best practices of performance and persuasion, which is, how to make appropriate eye contact, how to, micro-connect or look at 14 people in 3 seconds. So you just get a little touch, or how to direct the audience's attention, the jury's attention to one side of the stage or the courtroom or the other, depending on, the story you're telling. These are all discrete skills. The more you practice these skills, and then you get a chance to put them into action in the courtroom, but you got to practice your skills. But on top of that, you got to learn the strategy, right? You got to read the books. You got to go to the conferences. You got to learn how they're putting these cases together, how they're, what experts are they hiring? How are they using those experts to help prove their traumatic brain injury? I mean, so much strategy. What questions, like the question I just gave you on voir dire, I've been doing, around this for a long time, but, I've heard different voir dires on brain injuries or invisible injuries. And, and maybe what I've come up with is a summary of all of them. I don't know, but I think it's a really good voir dire. And I think that that as a trial lawyer, you should have a script or a prepared phraseology for every subject you want to cover and everything the jury could say to you. Because like if a juror says to you, Mr. Shaked, I understand your client's been terribly hurt, but golly, and I understand civil justice, but I have no idea how we would go about figuring out this number. I mean, just none at all. I know you said it's bad, but it may be real bad, but how does that equal money? I mean, nobody's selling their brains for money, and you have to be able to respond to that. Most lawyers, the typical response is what? Hey, I'm going to show you how to do it at the end, and the judge is going to give you the law, and if I show you how to do it, you take the law. The question is, are you able to do it? Are you willing to do it? Which, it's fine, but on something like that, I think whenever that's resistance, right? So you're going to get a lot of resistance if you're doing a good voir dire, right? When you tell them I want $50 million, you're probably going to see some resistance. Unless you're doing it in front of a focus group, you paid everybody $200 to be there for 2 hours. They're going to be like, 100 million, 50 million, let's make it 100 million for God's sakes. Don't short yourself, son, right? But it's not real. And so when somebody says that, it's, so whenever there's resistance, you have to meet people where they're at. It's like, Sagi, that's a really valid point. Or, that's not saying you're right, but saying that's a valid point you brought up there. How do we figure this out? How do we calculate this number? And, and then you say, you can either address it right there or you maybe decide to spread it. Who else is kind of like Sagi? They understand this whole concept of civil justice, but they just really don't know how we'd figure it out. And you see a lot of hands go up, right? Because how the fuck's supposed to figure this out? And now you're addressing a confusion that in the back of their minds, probably a lot of people have. And then the next part is like, folks, things like medical bills or lost wages, and those are the value or the cost of those things is easy to figure out. We just pull out our phones, open up the calculator, push in the digits, and hit the equal sign, and we know what number to put on the verdict form, right? We know what the cost is. We know what the value is because it's very objective. But things like loneliness, isolation, inability to sleep because of chronic pain, having to take 25 pills every morning and every evening just to have some chance at life, all these, not be able to hold your grandchild or, go on a walk, with your loved one. These are all human experiences that only a human being could really understand. Not the cost or the price, but the value of. And I think that the people who founded our country some 250 years ago, I think they understood this. They understood this concept. And that's why, people like us have been gathering in courtrooms like this to listen to the evidence, to listen to these human stories, and to ask to sit here and be, to put not the cost or the price, but the value, to act as appraisers for these human losses. And so it's not a perfect system, but it's, it's really, I think it's all we got. Does this kind of make sense to everybody why we do it like this? And it does. And it's like, can we think of any better way to do it? And then it gets to jury. It doesn't, people are like, well, they didn't really answer the question. I'm like, of course you didn't answer the question. It's a reframing, but understanding why we do it and the challenge. And it's not easy. That's why it takes time. And that's why we all had to set aside, put time from our lives aside to come here. Because, if we could just put it in a computer program, it would be a lot easier, wouldn't it? But every human's different. And every story is different. And that's why we have to listen to this one, if you choose that this case is right for you. Something like that, right? So it's all about,
I like it.
The structure, being ready. So if they say you're a greedy lawyer, or, that's a ton of money and you're a greedy lawyer, the double attack, right? Sagi, you brought up 2 points there. And it's okay if I address it with you one at a time. Boom. People's defenses drop, okay? As soon as they say, you're listening to me, I've been heard, it's a lot easier to have a conversation, right? Think about the political fucking climate. If you're like talking to somebody who thinks differently and you're like, you're a fucking idiot if you think Trump's a good president. And they're thinking like, if you think Kamala would have been a good president, you're an idiot, right? And it's just like this total clashing instead of like, what things do you like about, what policies do you like about his? Where can we agree? Can we agree that we have a constitution, okay? That everybody should be bound by the constitution. So we're finding areas we can agree, but it's all about trying to find the areas that you can agree upon in order to really have a discussion. So anyways, voir dire. You got to be really a lot of practice, be ready for it. And guess what? We have it in Huntington Beach, Sagi. Besides all these cool master classes, we got a voir dire, a live voir dire track.
I love it.
So Pat Salvy's going to do a med mal voir dire with a real focus jury, and I'm going to have a camera on the focus jury and on the presenter, and that people have to kind of sign up for it ahead of time. So the presenter is going to meet with his voir dire students ahead of time, kind of go over the case that he's doing a med mal case, right? Go over the facts of the case. Joe Freed's doing a trucking case, and the case that we're doing on using as the exemplar is actually a Joe Freed case. And so he's going to demonstrate how he would voir dire because, there's drugs. Of course, there's drugs in the motorcycle system. Of course, there's, what kind of wrongful death case would you have with, your victim doesn't have a little drugs in the system? What kind of world do we live in? But Ben Rabinowitz is going to do a wrongful death voir dire. So I'm pretty stoked about this whole, because there are no really good, you look on CVN, how many voir dires are on there? Maybe a couple. That's it. And they never show the jury, right? But to have a camera on the jury and on the presenter and be able to cut back and forth and edit it, this is the first time I've ever done this. And I think it's going to be very different. It's going to be in a smaller room. So it's not going to be like an auditorium, because that'd be more like like your regular courthouse, not like you're in some federal courthouse that's, that looks like an auditorium, right? Some of those federal courtrooms are so big, you're like, My God, I remember first time walking to federal court, I'm like, how do they have a trial in this? This place is so big. And it was a very scary place, that federal court. Mean judges for the most part, too, I have to say for the record. I'm more of a state court kind of guy. So, Sagi, I think we've covered all of our topics for the day. Oh, let me ask you this, Sagi.
Sure.
You had this colorful career, and honestly, a lot of times success changes people. And, because Sagi and I kind of met when he was just starting his little rise. But I can honestly say, for the better, like Sagi's still the same guy, even with all the success he's had in these 9-figure settlements. Didn't become
Thanks, Dan.
didn't become a dick. Some people
Very
really
nice
become
of you to say.
jerks. But and so, which is really cool though, because and what's your next case you got coming up, Sagi? Because I know you're always getting ready for trial, and that's why you couldn't come to boot camp.
Right. Yeah, we have a medical malpractice, wrongful death case coming up. I have a hearing later on today on it, but we have a trial coming up on May 12th. That is
Here's what we do. We get
Yeah.
this case put off until like late June, July, and then we bring that case here, and then you rack Salvy's brain about some of the case there and get his input, insights, and Lloyd Bell will be there too, so you can hit him up for a little bit of how they might do things. And then we put it off until like July, and then your friend Dan comes in, like I did for Connell, to help him get his record verdict. I just carry your briefcase around with you, help you prep your witnesses, be your most important number 2. How does that sound?
That sounds like a plan.
Maybe
Sounds
let me
like a
pro
good
hockey to do a witness. Connell didn't have the confidence in me back then, but I've got 12 because we were up in Bakersfield, because it was so funny, because that's where I met like Danny Rodriguez. You know Danny Rodriguez out of
I don't.
Bakersfield? He's a real great lawyer, and my buddy was talking about him the other day, Ryan Medler, because Ryan went to the Spence Method back in 2022, and Daniel was one of the instructors there, and he's like, so many, most of these trial lawyers, it's like they're like super alphas. Like, you take like a Raleigh, a Panish, a Claggett. It's just their nature, right? But they're like, Danny's like the most humblest guy. Like, this is the first time I always invite Danny to teach. And every time he's like, no, I'm just going to come as a student, and there he is, going to class and everything. And he's got like 8 9-figure verdicts. And settlements. Huge verdicts. And all he does is try cases. Actually sent 2 of his associates to my boot camp last weekend, one as a participant and one as a juror, and really invested his people too. And, they always come to my conferences, which I really appreciate, but just, super humble guy, super great guy. He's teaching about opening statements because he got like a record verdict in Iowa on like a $35 million verdict on some real tough TBI case. But that's the challenge, is tough cases. That's why we need tough lawyers. Sagi, guess how we're going to finish off here, buddy?
You tell me.
Cross-examination, because out of all the stuff, and that way, let me think. Oh, if anybody, Sagi, before we do the cross-examination, how did people get a hold of you? Because some people might have heard this cross-examination piece before, but I believe in repetition. Until you can do this piece across without thinking about it, and you get all the hand movements, emotional, facial, emotional state, voice, pacing, legible writing. Unless you can do all these things, you need to keep practicing. That's why I do it at the end of every program. But people need to get a hold of Sagi Shaked. Let's say they got a brain injury case and they need to have questions about it because they're not sure of something and they just got their bar card 3 months ago and they're, terrified of screwing up and, So how do people get a hold of you?
Sure. Yeah, I can give. I'll give out my cell for those who want it. It's 305 790 5037. You can also email me. It's Sagi at shakedlaw.com.
shakedlaw.com. And mine, if anybody needs me for anything, of course, my cell is 248-808-3130 and Dan at triallawyeruniversity.com. And if it's anything that's covered in this program that you would like a copy of, even that, TBI or invisible injury voir dire, it's a script. You shoot me an email, I'll shoot you a copy. Because we're going to do actually at this last program, people were like, you got to do a voir dire class. It's, we teach all these scripts because I was doing the apple pie voir dire and, some of these other scripts are because a script is the starting point, right? That's where you kind of, you flow from there. But the cross-examination stuff, I think, is honestly my most significant contribution to the plaintiff's bar as far as the skills part, because so many people, everybody knows the importance of cross, right? They say, closing is for show, cross is for dough, or you close through cross. And, there's books written upon it. And Posner and Dodd wrote Cross-Examination, Science and Technique, which I think is the Bible. I think it's a great foundation. But it's a performance art, and you have to be able to perform. And so this cross-examination of the defense medical expert is an expert cross that can be extrapolated or it could be altered to hit any expert. Obviously just change what, the consequences are of doing a biased evaluation or a biased examination or a biased analysis. If we're talking about if we're talking about a biomechanics expert. So, teaches the fundamental skills, which are, of course, leading questions only, which is an obvious one. But then you see these people starting a question with a verb, like, do you agree? That is not a leading question. Agree? That's a leading question. Is that true? Is not a leading question. That's an open-ended question, inviting a narrative response. So just never start with a verb, but one new fact per question. I see some of these questions that people ask and they go on for a paragraph and they have 5 different facts in it. And the witness says no. And, the person gets frustrated. It's crazy, but it's a teaching. Remember, we're teachers. Repetition, one new fact per question. Looping, which means to establish a fact, then repeat that fact in the next question. Dropping the taglines like right, correct, isn't it true, true. Dropping all the filler words like and, so, effectively using a flip chart, learning how to write legibly, putting one topic per page, being in control of your emotional state the whole time. So many people, they say cross and they go, and they get like aggressive tone instead of like a kind tone. But for cross, I think there's really 2 dominant emotions. What are they, Sagi?
2 dominant emotions for cross?
Yes. That should be in 98% of your cross.
Tell me.
Inquisitive, like, you're curious, the curious state. And then secondly is disappointment. And when you impeach them, when you prove they're liars, not anger, not frustration. Joe Fried says, if you get angry or frustrated anytime during the examination, it's like you gave that, witness a remote control and they just pushing buttons and you're like, and instead of always being intentional with your emotional state, slowing down the pace of our speech. Most people speed up in cross. We could watch you on CBN. I guarantee, compared to direct, your cross is much faster. Just the pace of your voice. It just happens when the adrenaline's in the body, unless you train around it. So, and also like bringing the jury in, appropriately. Some people are comfortable asking all their questions to the jury. I'm not. I think that when you turn to the jury and you ask a question, it should stand out. So those are the key skills of cross-examination. So I know you've seen this before, Sagi, but you're about to see it again and experience it again, right? Because if I say, Sagi, I'm Dr. Dan, do the cross at me, I guarantee you couldn't do the cross.
Oh, we did a little practice run in New Orleans. I just don't remember it, but yeah, we did a practice run.
Oh, yeah. We're at another conference. I'm like, Sagi, I got this new shit. You got to see it. He's like, come on, man. We're in New Orleans. We're at another conference. I did my 3 hours a day. I'm like, no, this shit's going to be a game changer. So Sagi and I, and maybe one other person, were over in the separate area of the hotel. And I'm getting up there doing a line, having Sagi get up and practice it. Because, I got to make sure you're always learning, Sagi. I would say, Sagi, you're my future, buddy. How yours, the track, I want my career to track your career just a little bit later in life than you, due to my age. But
Never
here's your
too
cross.
late.
Ready? Never.
Go
Thanks
ahead.
for the inspiration, buddy. Never too late. So here it is, Sagi. You ready?
Go ahead.
Doctor, you're a board certified medical expert.
Correct.
To become board certified, this requires advanced education.
It's true.
This education, it takes place after medical school.
That's correct.
But while you were in medical school, you did take classes.
Everyone takes classes.
Well, one of the classes that you took was on how to conduct a proper medical evaluation.
Yeah, you would say that, yeah.
Okay, so that's what I call a connected loop. Every sentence begins where the last sentence ends. Very easy for the jury to follow. It's like breadcrumbs. Now we're going to talk about a proper medical evaluation. Doctor, you're trained that a proper medical evaluation, it must be impartial.
That's true.
And if you notice that statement, there was a lot of pauses. But when I pause, I actually inhale because people don't breathe on cross. They try to get out these long sentences without any extra air coming in. And it tends to cause their voice to trail off and speed up. Things that are no good for teaching. So on my flip chart, I write proper, and then number 1, impartial, capital letters, and then a number 2. Obviously, this is filled in for purposes of speed and efficiency. So now we're going to define it. Doctor, by impartial, what we mean is that you're not an advocate for either side.
Yeah, I'm independent, correct.
Doctor, you're trained that a proper medical evaluation must not only be impartial, so I turn and look at it, that's glance control, but it must also be objective. So then I write down objective on my board and I put a number 3. Now we're going to define it, of course, because we have parallel structure. By objective, what we mean is that you don't cherry pick the evidence to support a desired opinion.
That's true.
Doctor, you're trained that a proper medical evaluation must not only be impartial and objective, but it must also be complete.
Correct.
By complete, what we mean is that you consider all relevant information.
It's true.
All right. So in your whole career, in 25 years, Sagi, based upon those definitions, how many defense experts have you ever come across that you would say were impartial, objective, and complete?
None.
0, right? But they're
Correct.
all going to say that they are because they have to. Because if they were to raise their hand and say, hey, I'm a paid, look, Mr. Shaked, before you ask me questions, let me just fess up to the jury. I'm a paid whore and I will say anything that they want me to. That would make your cross a little bit easier, wouldn't it?
Yeah, it never happens. But yeah, you're right.
And speed it up. Of course, it doesn't happen. What fun would the game be if they just admitted their biases and that they're liars? So we have to prove it. Whenever especially when I was practicing full time, whenever I'd get to cross-examination, it was usually cops. Or like people that claim to be victims. I'm like, am I a better cross-examiner than they are liar? Because that was always my personal challenge to myself. So now we got to do the opposite, right? So, Sagi, the opposite of a proper medical evaluation, one that's impartial, objective, and complete, well, that would be a biased evaluation.
Okay.
And you're trained and you know that there are certain risks associated with a paid expert's choice to conduct a biased medical evaluation.
I would say so.
Okay. And one of those risks is that the jury could be misinformed about the patient's condition.
That's true.
So on that one, if you were just listening to this, I turn and I address that part to the jury. It's like, hey, folks, be careful. This expert may be misinforming you. And then, of course, I have it says biased and then number 1, misinformed. So I'd put number 2. And so, doctor, now we're going to loop it. You're trained and you know. So that's an example of stepping, right? You're not just trained, but you actually know this, that if a paid expert chooses to conduct a biased medical evaluation, not only could the jury be misinformed about the patient's condition, but they could also be misled as to the extent of the patient's injuries.
I would think so.
And so, of course, I write misled, and I put a number 3, queuing up the jury, more is coming. Doctor, you're trained and you know, of course, we're looping, right? That if a paid expert chooses, it's a choice, it's not an accident, to conduct a biased medical evaluation, not only could the jury be misinformed about the patient's condition and misled as to the extent of the patient's injuries, but perhaps worst of all, they could be deceived into undervaluing the human harms and suffering that were caused.
I agree.
See how my tone became tragic. This is the worst of all, Dr. Shaked. So, doctor, here's my question. Or let me ask you this. I call that a refocusing move, like squirrel. I think at the end of every cross, you should have something like that to let the jury know these 20 questions that came before. This is why I asked them all for this very valuable setup question. On December 27th, 2022, you had a choice to make. So tell us all, what did you choose to do?
I chose to, what was that? A very impartial review and give an unbiased evaluation like I did earlier today on direct.
So let me get this clear. You want this jury to believe that, in fact, that you, on this date, did a proper medical evaluation, one that was impartial, objective, and complete, like you were trained to do. And you didn't choose to violate your training by conducting a biased evaluation because you you knew and you were aware of all these risks. Is that what you want this jury to believe?
Right. And that's what I did. I did a proper medical evaluation,
Thank you, Dr.
an
Shaked.
impartial one.
Of course you did. So, but this thing can be adjusted for any type of expert, like a biomechanics expert. It would just change, the risk that the jury could be misinformed about the forces involved in the crash, right? And if they're misinformed about the forces, they're going to be misled about the potential for injury. And if they're misformed and misled, then they could be deceived again into undervaluing the human harms and suffering that were caused. But you just have to play with it. And people are like, well, how about if I have multiple experts? I'm like, well, you have to summarize. You can't go through the whole, because remember, it's for the jury, not for the expert. So kind of summarize it. But anyway, Sagi, this is your lessons. These are a lot. I know you were here to teach people about a little bit on the brain, but you also you got to learn a little bit on voir dire and cross-examination and direct exam. Always learning. I just wanted to make sure this was going to be a good learning experience for you. All right?
Sounds good.
All right, Sagi. Thanks for visiting. And
Thanks for having me.
When am I going to see you next? I'm not going to see you till Huntington Beach, right?
Correct. Well, I'll see you are you going to Jersey for the Boardwalk seminar? Okay.
No,
I'll be teaching there.
I know you will be. That's not my kind of. I've been there before. It's like way too many people, every type of lawyer under the sun, and it's I'm more of a California guy.
I get you.
I've been to that boardwalk. It's fun though. It's big. I did a podcast earlier with a guy named Greg Promushkin. He's from Philly, but he goes to that one. So maybe you guys can connect there. You like him. He's a character.
Yeah, I met him on one of your boot camp things.
Oh yeah. That's right. The one you almost came to, this last one. Don't you worry. I haven't given up on you, Sagi. A lot of people would give up on their friends after, numerous, half a dozen rejections, but not me. Everybody knows one thing I am, it's persistent.
You are persistent.
Can't shake me. That's persistence. All right. Have a great one, buddy.
All right. Thanks for having me. Bye, everyone.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.